Hello, and welcome to Afternoon Tea with Karen. According to the Greens and their national nation's policy, they intend to review the native title legislation to make it consistent with the UN Declaration on the Rights of Indigenous Peoples. However, I was a little bit in the dark about that one because it's well and truly happened back in 2021.
Government Business Orders of the Day. Number 1, Native Title Legislation Amendment Bill 2020, resumption of second reading debate.
Minister.
Thank you, Madam Deputy President. When we last adjourned debate on this matter, I was about to take on some of the matters that have been raised by those opposite in relation to their concerns about this bill. And I'll take those through one by one. First, let me deal with the amendment that's been moved by Senator Thorpe on behalf of the Australian Greens. Now, the proposed amendment seeks to do two things. The first is to expand the scope of proposed section 47C in Schedule 3 to the bill and to omit, effectively delete, the remaining 8 schedules of it, effectively gutting it of most of its volume. The Australian government recognises the importance of engaging in good faith consultation with Aboriginal and Torres Strait Islander peoples in relation to the decisions that affect them. So, consistent with the principles under the United Nations Declaration on the Rights of Indigenous Peoples, we have endeavoured to make sure that can be given effect. The bill has been developed through careful consultation, extensive consultation, including with native title representative bodies, registered native title bodies corporate and other Indigenous stakeholders. It represents a balanced package of focused reforms supported by a broad range of stakeholders in the native title sector. And the bill is about delivering practical solutions that will ensure the native title system continues to meet the evolving needs of all stakeholders, and in particular, always in particular, traditional owners. The bill seeks to improve outcomes for native title holders by supporting the capacity of native title holders to control their rights in land through greater flexibility in internal decision-making, so that native title holders are able to make their own decisions about how they do that in a way that works for them and their cultural practices. It seeks to improve outcomes for native title holders by improving claims resolution and agreement-making processes, and also by improving pathways for resolving disputes following the determination of native title. So the government considers that the form of this bill operates effectively to provide practical improvements to the native title system for all people involved in it, and shouldn't be amended or delayed from being passed. I thought I might say some things about section 47C. Now, Schedule 3 will amend the Native Title Act to enable parties to agree to disregard the historical extinguishment of native title over an area that has been set aside or vested to preserve the natural environment, such as a national, a state or a territory park. Now, many native title holders have traditional and cultural connections to areas that are covered by national, state and territory parks, and we recognise that. We recognise its importance. This is therefore a focused and positive measure that is specifically seeking to enable native title rights to be recognised in those areas. The proposed amendment on sheet 1185, however, seeks to expand the operation of this provision to include other Crown land beyond park areas. Now, you might say, what's wrong with that? But it operates in isolation from understanding the rest of the Act around it. For instance, the Native Title Act already contains provisions which allow prior extinguishment of native title to be disregarded in certain circumstances, like section 47 deals with it in relation to pastoral leases, Section 47 capital A deals with it in relation to beneficial Aboriginal reserves, and 47 capital B deals with it in relation to vacant Crown land. So in many ways that is a change in search of a problem. The current drafting of proposed Section 47 capital C that's contained in Schedule 3 of the bill has been subject to extensive consultation with a wide range of stakeholders, and it is strongly supported by native title holders. It wouldn't be desirable to expand the operation of that provision in the way that this amendment suggests it should, without further consulting with all of those relevant stakeholders, without giving them their say, because it's important that all relevant stakeholders in the native title system, including, of course, native title holders, but also state and territory governments, get their chance to contribute. And that's particularly important given state and territory governments will be the primary government party to agreements required under proposed Section 47 capital C. This bill is a package of reforms responding to different interests of different stakeholders in the native title system. It wouldn't be a good idea, it wouldn't be desirable in the interests of those who participate in the system to split it from the reform package. In the time remaining, I might deal with a concern raised by Senator Dodson about the potential for continuing validity of ILUAs affected by fraud. The bill makes it clear that the validity of a future act done in accordance with a registered Indigenous land use agreement is not affected by the subsequent removal of that ILUA from the register of ILUAs. Now, that amendment doesn't affect the present position at all. It only clarifies it, and additional material has been included in the replacement revised explanatory memorandum to make sure it is indeed crystal clear. These measures would implement recommendations made by the 2015 COAG investigation into land administration and use to clarify that the removal of details of ILUAs from the ILUA register does not affect the validity of future acts done under it. Now, while that measure wasn't supported by the expert Indigenous working group advising the COAG investigation, further consultation with states, territories and relevant stakeholders was recommended, and then that consultation occurred during the development of this bill. So in a sense, the position has moved on from the point of the 2015 report. The objective of the amendment is to ensure that there is certainty to all parties around the validity of any acts that are done pursuant to an ILUA which has been removed from the register, including, for example, in circumstances where the ILUA has come to an end. It would be quite perverse if an ILUA that's come to an end faced the invalidity of the acts done under it from that point onwards. There have been to date very few applications to the Federal Court to remove an ILUA from the register on the basis of fraud and duress, and none of those have been successful. And there's several reasons why it wouldn't be desirable to retrospectively invalidate future acts under an ILUA that's been obtained as a result of fraud or duress. First, the implications of such retrospective invalidation may be very complex and would raise difficult questions such as, for example, whether benefits already received by the native title groups under the ILUA should be recouped. And surely that wouldn't be a good thing for native title holders. Secondly, there may be parties who entered the ILUA in good faith, who've done nothing wrong, who would nevertheless suffer as a result of the retrospective invalidation of that future act. And third, it may not be appropriate for all future acts covered by an ILUA removed from the register to be invalidated. It's worth saying these measures don't affect a court's power under Section 199 capital C of the Native Title Act to remove the details of an agreement from the register, and these measures do not affect the court's ability to deal with the effect of any fraud, any undue influence or any duress. I hope that assists those opposite to see the government's position on this matter, and if there are any further concerns about it, I'm happy to take that during the period for questions. The time remaining, I might just conclude with this. The government considers that despite significant progress, there is scope for improving the native title system to improve the recognition and management of native title rights and traditional lands. This bill demonstrates our commitment to the native title system, and I thank all senators for their contributions to the debate and commend the bill to the Senate.
Thank you, Minister.
And something interesting from last year.
Hey, I'm Emma Garlow and welcome to Paint It Black. Do you know that to this day, Aboriginal people still have to prove that they have a connection to land despite everyone knowing that they were here first? Australia has never been ceded and our sovereignty coexists with the Crown. I spoke to Yamaji Elder Thomas Cameron about what he thinks of native title.
Chuck it out the door. It's useless. Chuck it out the door and mend it, because it's not of any relevance to what we're doing. It's not of any relevance to protect right people for right country. It's not relevant to protect what we do, preserve our language, our totem, our dreaming, our place of belonging, our identity.
The Native Title Act of 1993 was drafted in response to the Mabo case, which was when Eddie Mabo successfully proved that the Meriam people of the Torres Strait had rights to their land. The Mabo decision overturned the legal doctrine and fiction of terra nullius, meaning land belonging to no one. This is significant for Aboriginal people, as it proves that Aboriginal people were here since before colonisation in 1788. Aboriginal people have been here all along.
You told my people that your system was best. We have come to accept that. We have come to believe that. The dispossessed, despised, adapted to your system.
So, what is native title? Native title is a system set up so Aboriginal people can prove that they have an interest over land to do things like have Indigenous land use agreements, negotiate over future acts on land, or have a right to negotiate. ILUAs are normally commercial in confidence documents, but recently 2 ILUAs have been published online. The Yamaji Nation Agreement was published a couple of years ago, and this year the Jawal Agreement was also published online. Publishing agreements can ensure there is transparency around what traditional owners can negotiate in terms of best practice. Native title is important to ensure traditional owners can have a say, but there needs to be more rights and protections in terms of traditional owners, because native title doesn't cover everything. There needs to be more protections for water, for air, for cumulative impacts on sites. It could be death like 1,000 cuts, and especially for contaminated sites after there's been a mine or a development on the land. Native title is not all-encompassing, especially considering the race to stop climate change, the need to reach net zero, and the amount of renewable energy projects we need. Native title was not created with climate change and renewable energy in mind. The number of renewable energy projects and critical mineral mines needed is increasing significantly. This is the Western legal system in which we operate. But native title, it doesn't recognise Aboriginal law, which is LORE. However, people like Thomas say too much money gets wasted on administration, like lawyers' fees and accounting fees.
So these are the issues that's going on, because money as in the past, with my experience working in 37 communities in Fitzroy Crossing, and also Kununurra and also in Wyndham, is showing that money gets wasted on administration. It doesn't go to where it's meant to go. So we ask for help, but we don't get it from those sort of people. So we look at other alternatives, other options, and we do get help.
What's the alternative? There is an opportunity to make native title more inclusive. But for some people like Thomas, they either don't want native title or they want it amended. Aboriginal people are the traditional owners of the land, so we need to make sure the way that decisions are made and governed are the same for both proponents and Indigenous people. Aboriginal people need the ability to say no to projects on their land. Currently, this doesn't happen. Thanks for watching Paint It Black with me, Emma Garlett. Don't forget to subscribe so you never miss an episode.
And that will do. See you later. Bye.